Make
Yes.
this enough. My lord, in regard to item 9, my lord, this is a matter relating to the settlement of the insurance policy. My lord, the substantial part of the policy we have already settled. You are, my lord, in regard to marine policy, there is some dispute, so we are going to settle it very soon. Let it come after vacation, my lord.
I will waiting for the petitioner in this matter.
Okay,
After the vacation, it may come.
okay. Mr. S. Sharma,
Yes, sir.
S. A. Sharma, learned counsel for the petitioner, as well as Mr. S. Datta, learned senior counsel for the respondents number 2 to 4. Submits that the settlement settlement attempt is at its is still going on. Accordingly, leave this matter after the vacation.
Obliged.
Late to July. The vacancy to item number 6 and 7. I'm waiting for the petitioner in this matter. These matters were for a direction from this honorable court to allow us to deposit the dues of the tea estate in installment basis. And that order was passed, and accordingly we are paying. So now after like 8 years, I have lost contact with the clients also. I'm just asking for 2 weeks time to find out the updated position, whether the installments have been all cleared or not. Because the PF has also not been able to give me the information.
2016 matter, I think by, y'all have kept 8 years have
Some
passed.
time may be given for getting the instructions, Lordship. We also do not have the updated instructions.
You'll get it by next week. Next week. Right, Mr. A. Sharma, learned counsel for the petitioner, and Miss
M. Devi, Lordship, for respondent numbers 2, 3, and 4.
N. Devi for respondents number 2 to 4. Pray for time to obtain instructions whether the matter has become infructuous. This is the matter in the next next Monday. Next Monday.
Have it on Wednesday.
Why?
The PF has asked us to appear before their office on Friday, as per my instruction.
Then
So only then they will get the instruction as to what is the present accurate position of this installment payment. So therefore, at least Wednesday, Monday may be a bit short.
okay, wait.
Obliged.
Huh? Eviction. Eviction, you go to bench 5. No, sorry. Let me see. No. Relating to land matters, bench 5.
Make his lordship. My lord, item number 48 of supplementary cause list, my lord. We have filed an additional affidavit on behalf of the petitioner, my lord. It may kindly be called for, my lord. I'm deeply obliged.
Huh? New matter, old matter? Huh? What? 23 matter.
Yes. But work order is 2019 membership. So that's why it's
What is the urgency?
this is payment is the one for district something. So
Payment, contractual dues, no hurry.
let's be
Give it.
2020. 20.
I get permission, item number 50 lordship, 50.
50. Yes,
That may come out after 1 week lordship.
no. We'll take it up.
We said it on the last one, but payment had to be installed.
They will put it.
I think 29, my lord. Yeah, rather than the petitioner expired, my lord, but I cannot substitute petition as the filed, my lord, because next day we cannot collect. So after puja, if there, we can take.
Mr. Counsel, this is the same excuse you took last time.
My lord.
Please give me that item 29. 29, correct?
Yes. Respondent 4 and 5, best service completed, my lord. But
Mr. Counsel, that's not the issue.
yes, we have lost the contact.
You have lost the contact, then we'll close it. If he,
One chance may be given, my lord.
you see, this is the same, submission you made in February 23. 1.5 years have passed since then, nothing remained. I'll
One chance may
dismiss.
be given, my lord.
No. You, what chance? We have given you more than 1.5 years. You're not doing anything.
Lost the contract, my lord.
Huh?
Lost
If you have lost contact, then just finish another matter. Will be called. You come just dispose it off. You not wait this way. Yes, what is the instruction?
We need some more time for instruction, Lordship, but the instruction will come from the state excise instead of BTC, Lord.
When is it coming? The last time you took time only for that.
I-
It's a small issue. Nothing great.
1 week maybe.
Yes, Mr. P. Goswami. It's a small issue. He had applied for a IMFL on license. No objection, everything given, nothing is being done. That's all. He wants to know why.
Okay.
And this case has been listed since August. That's all small. You just have to take a phone call and ask them why, what's happening. That's all.
My lord, we fix it tomorrow, day after, my lord, I will bring the instruction.
Okay, Mr. P. Goswami, Leonard, addition AG submits that he will obtain instructions as to why the petitioner has not been awarded the IMFL on license still. This is a matter of witness.
Out of the 3 crores, 59 lakhs, 64,595. I have been paid with 2 crores, 96, plus 12,100. Has already been paid. What if you also come to the advance free for payment of page 30, remaining 53 lakhs is still in. At page 40.
Yes, what is your case?
Now,
Lordship, there is arbitration clause, Lordship, as per last order of the honorable
No,
court.
maybe, but whether it's necessary to go for arbitration clause, do you admit that he has to be paid 53 lakhs or not? That's all.
That instruction I have to obtain, but I presently obtaining the arbitration.
page 38, for a moment. What my argument is submitting arbitration, it's a claim clause, dispute the court of it.
Lordship.
Page 38, may I read?
Yes,
So
The subject said it above. I have the order to inform that the government of Assam in the final department sanctioned the sum of 63 lakhs 32,415 only for the work of construction.
anyway, right.
This is the report of the circle officer and the
Right.
issue is also very there to.
Lordship, earlier
There are
occasion,
photos of the.
Huh?
earlier occasion, 2 matters honorable court has directed us to obtain that instruction. I have obtained and honorable court dispose of the better, Lordship. Kindly press Nipul Polita, Lordship. I have submitted one order, Lordship,
Huh?
which has been sent for arbitration, Lordship.
No,
Similar.
madam, it's not a question of, you see, arbitration is when there is a dispute.
Dispute.
Lordship, it is, your Lordship's order was there, Lordship.
No, when there is
See
a,
the
when there is a dispute with regard to the amount.
Lordship.
Yeah. And recently I have been paid with the transaction.
Then, Lordship, I need to take instruction, Lordship,
Transaction is before lordship. What should get disposed of? This is the arbitration clause.
No. You see, I'm not disposing it off. Let them file an affidavit
Lordship.
as to whether the amount is disputed or not. That's all.
Lordship, if your lordship comes to.
Mr. Counsel, this is not, they have got to make a reply. That's all. Third, Mr. Ardha, the counsel for the petitioner, who submits that the balance contractual dues of the petitioner amounting to rupees 53 lakhs has not been paid. Issue notice returnable in 4 weeks. Ms. R.B. Bora accept notice on behalf of the BTC,
BTC, Lordship.
while Ms.
And that's what we don't need.
M. Das appears for the PW. The council shall obtain instructions and file affidavit by the next date as to whether the amount claimed by the petitioner is an admitted amount. Whatever it is. This is a matter after 4 weeks.
Diploma.
Next. What is this? Yeah, this is part of that. What is this? Item 3. How much?
Payment of-
How much?
The amount is 18,19,590.
Mr.
M. Sharma.
M. Sharma, learned counsel for the petitioner, submits that the contractual dues of the petitioner amounting to rupees 18,
18 lakhs, 19,000,
80, 18,
19,000,
19, 590 has not been paid. Issue notice, returnable in 4 weeks. Ms.
M. Kalita.
M. Kalita, accept notice on behalf of
All the respondents except respondent number 3, Your Lordship.
all the respondents except respondent number 3, which is who is represented by, who is the finance? Who's that, who's to come? Mr. B. Chaliha, no, A. Chaliha, A. Chaliha. This is a matter of the 4 weeks. To enable the respondents to file the act.
Obliged.
for
Regarding the arts, page 38 minutes.
Huh?
Page 38. That's already settled in the petition act. Periods of the ones in 2024, 36, 2025. The petitioner is running the hard split matters. Many times, say, came to the knowledge of the petition that's lately, that's a tender notice. Page 40 minutes. 40, tender notice was issued. I am running the budget without any disturb. It creates some apprehensions.
No, Mr. Counsel, you were settled with the bazaar.
Yes.
For which period?
Page 38 minutes.
Okay, yes,
1/7/2024 to 30/6/2025. Page 38.
yes. Then what happened?
I'm running the budget matter without any disturb whether lately it came to the notice. It came to my notice that the tender notice was issued by the department. Page 39 matter. Lately it came to the notice matter. And it becomes apprehensions in my mind many times. I'm running the budget. February 2024 matters. Another notice was issued regarding the same cards, page 34. Paragraph.
Yes, madam, what is this?
Lordship, I need to take instruction because whether he has paid the amount or not. that
Are you
is-
running the market?
I'm running the market.
Have you paid the revenue?
I've already paid.
So there is nothing wrong with the settlement.
There's been nothing from me.
All the terms and conditions have been complied by you. Correct? All the terms and conditions
Yes,
for
sir.
running the market have been complied by you. Correct,
I shall take instruction also, so that may be given, whether
okay. Yes. Heard, Mr. H. A. Sarkar, learned counsel for the petitioner, who submits that the petitioner that the Kata Jar Goramara hut has been settled with the petitioner at the rate of rupees 52,370 with effect from 1/7/24 to 30/06/25. Full stop. However, the who has issued this tender notice?
tender notice CSD market.
However, the respondent number 5 has issued tender notice dated 5/6/2024.
It's
for the same market.
in,
Huh?
26 to 2020.
What?
It's 39. It's 39. Lately it came to my knowledge. It's
What?
39.
39 is an order. 39 is an order.
40.
That's what I'm reading out. That's what I'm reading out. What have I said? The tender notice dated 5/6/2024 for the same market for settlement for the year 2024-25. The petitioner accordingly apprehends that the market will be settled with some other person, during the validity of the settlement period of the said market with the petitioner. Ms. R.B. Bora, counsel for the BTC, shall obtain instructions with regard to the same. Accordingly, on the prayer of Ms. R.B. Bora, list the matter on
25.
25 or next Monday. Better, Monday, huh? Next Monday, 23. 23. What's up? Till the next returnable date. No settlement of the Katajar Dharamara hut should be made in person to the tender notice dated 5/6/2024. This is the matter on 23rd.
Deeply.
I said should not be settled.
Supplementary motion 48. 48 also was called for eviction and they will also be taken from that.
No, it's not come the affidavit. What is the issue about?
The issue here is this, we are a startup. And my lord, on earlier occasions, exemptions were granted to startup in respect of turnover and expense criteria. In the present NIT, that was issued on 7/9/2024, that exemption has been omitted. Our difference is, my lord, in terms of the central government notifications, the exemption to startup is a requirement. So our case is this, my lord, is in violation of that.
That is a notification of central government, strictly applicable maybe for a central government agency. We are a textbook corporation. We publish
You are a textbook corporate.
textbook corporation of the state of Assam. We publish textbook to be supplied free to the students, 53 lakh students annually. So now we are procuring papers, my lord, for publication of books, my lord, printing of books. My lord, we never intended to give any relaxation. We actually wanted to allow them to participate in the process, but we have used the portal of GEM, Government E-Marketing. In GEM portal, my lord, if we allow, my lord, these MSMEs and startups, my lord, that portal automatically, my lord, exclude other bidders and, my lord, grants exemption of experience criteria, which is not acceptable for us. That's why, my lord, with a conscious decision, my lord, we have cancelled the earlier tender, and the reasons are also recorded why we have done this. Because a person who has no experience criteria, we cannot take that risk, my lord. I've entered instructions, my lord, including the.
So the basic case of the petitioner is that the central government notifications should be followed, while your case is that it does not apply to you.
With the amount of volume of work, my lord, we cannot take that risk with a person who has no experience, my lord.
No, the question is, does it apply to you?
No, that doesn't apply to us, firstly. Secondly, my lord, though it was inserted in the tender, because, my lord, in the GEM portal, we cannot
No,
customize.
that is not under challenge, so that is gone.
In the GEM portal, my lord, though we have uploaded the tender, we cannot customize it. The system automatically takes and grants exemption for experience criteria.
For everybody.
For everybody, for MSMEs and startups, my lord. That's why, my lord, we have cancelled that tender. We have decided with the GEM that we will not grant this to the MSMEs and startups, my lord. Because without any experience criteria, my lord, we cannot proceed, my lord. It will be extremely dangerous.
What about in the past, what used to happen? In the past?
Up till last year, my lord,
customization was allowed because this paper, customization in the GEM portal was allowed, my lord. We could customize these are the criteria. The portal will also accept that because this papers, my lord, this paper that we require was not enlisted, was not a listed item, my lord. Now it's a listed item under GEM, my lord. So their system automatically grants exemption, my lord, which we are not agreeable, my lord. If we avail the GEM portal, my lord, we ask for a bidder with giving preference to startups and MSMEs, the system automatically deletes the experience criteria on its own, my lord, which is not acceptable for us. So that's why, my lord, we have consciously taken a decision that we will not go by that, my lord.
How can they say that, Milan?
That's on record, my lord. That's a part of our,
You may have taken a call, but is it enable such arguments? End of the day, the startups have been given a certain incentive by the government of India. How can a state government say Milord will not follow?
I don't know.
It's something like Milord, something is in the IPC and state will not follow IPC. We'll provide our own penal code.
I don't know. You convinced me, both of you. I have
Yes,
no.
I'm convinced, Milord.
I'm not sure.
let us see the.
Lords will kindly come to paragraph 4 of the petition.
Paragraph 4.
Paragraph 4. That the Assam state, that is the respondent authority, till the academic session 2021 had procured 70 GSM Maplito paper with watermark. It is stated that from the academic session 2022, ASTPPCL started inviting tenders for supply of GSM surface size Maplito paper with watermark. Till this session, my lord, they did not adopt the same thing. Now, from the academic session 2023, ASTPPCL started inviting tender for supply of the same 70 GSM surface size Maplito paper with watermark through government e-marketplace, hereinafter referred to as the GEM in short. Portal. GEM is a national public procurement portal and end-to-end online marketplace from where central and state government ministries, departments, CPSUs and SPSUs effect the procurement of goods and services. Now, how can they say my lord will not follow? Now please come to para 12, my lord. That as it has already stated here in above, that GM is a national public procurement portal and end-to-end online marketplace from where central and state government ministry department, CPSUs, SPSUs effect the procurement of goods and services. As such, in the humble submission of the petitioner, the letter dated 10/3/16, OM dated so and so and so and so are applicable to the facts of the instant case. Evidently, the impugned action of the respondent in omitting startup exemption clause from the tender is in violation of the aforesaid executive instructions provided. So this is our foundation which we have laid in the petition as to why, my lord, these instructions have the force of law.
Let us see these OMs.
Yes. Yes, and just the place 3 OMs, my lord. Please come to page 78, my lord. 78, 79 and 80. To all central ministries, etc., etc. Relaxation of norms for startup and micro and small enterprise in public procurement on prior enterprise prior to turnover crisis. Government of India has notified public procurement policy for micro and small industries, Order 2012, with effect from 1st of April 12, and so procurement from micro and small enterprise of total procurement by central government ministry has become mandatory with effect from 1st of April 2015. Government of India has announced Startup India initiative for creating conducive environment for startups in India. The startups are normally micro and small enterprise which may not have a track record. Just contrary to what my Leonard just said, this will have a technical capability to deliver the goods and services as per the prescribed technical and quality specification and may not be able to meet the qualification criteria relating to prior experience, prior turnover. In exercise of para 16 of the public procurement policy for micro and small enterprise Act, it is clarified that all central government departments, central PSU may relax condition of prior turnover and prior experience with respect to micro and small enterprise in all public procurement subject to meeting quality and technical specifications.
So this letter appears to pertain to central ministries and
Yes.
the central public sector
Yes,
undertaking.
Then Milord will kindly come to the next one. This is on Milord 25th of July 2016. Subject relaxation of norms for startup, medium enterprise and public procurement regarding. Government of India has announced startup initiative for creating a conducive ecosystem for growth of startups in India. Startups are defined in Annexure A of Action Plan for Startup. Same is available on the website of Department of So and So. The Ministry of Micro and Small Medium Enterprise by policy dated so and so has clarified that all central ministry departments may relax condition of prior turnover and prior experience with respect to micro, small industry in all public procurement subject to meeting quality and technical specifications. As per Rule 161A of the GFR 2005, the General Financial Rule, there is already a provision that all bidding documents should contain criteria for eligibility and qualifications to be made by bidder, such as minimum level of experience, past performance, technical capability, manufacturing facilities, and financial position. In view of above, it is further clarified that all central department, ministry department may relax condition of prior turnover and prior experience in public procurement to startups. And Milord will kindly come to the last page. Now, this is a clarification, Milord. It specifies where it should not be given. First paragraph I am not reading. A doubt has arisen if it makes optional for central ministry department to relax condition of prior experience and prior turnover in public procurement to startups. In this regard, it is again clarified that normally for all public procurement, the central ministry department have to ensure that criteria of prior turnover and prior experience for startup is relaxed subject to their meeting of quality and technical specifications. However, there may be circumstances like procurement of items related to public safety, health, critical security operations and equipments, etc., where procuring entities may prefer the vendors to have prior experience rather than giving orders to new entities. For such procurement, whatever adequate justification exists, the procuring entities may not relax the criteria of prior experience turnover. So, my lord, the government was also conscious of the fact that whether this policy of giving this relaxation to startups and MSMEs should be extended across the board. The government was of the view in such cases where procurement of items like public safety, health, critical security operations, equipment, where option has been given. But the whole idea is, my lord, this startup, the government of India's policy is to encourage startup. Therefore, the policy is to give them relaxation in matters of experience and, my lord, turnover. Now, the fact that it is known under the scheme of the, my lord, the 7th schedule of the Constitution of India, my lord, the state's power under whatever may be the field, my lord, mostly, my lord, it is subject to the central power. So state cannot exercise something which goes against the central prescription. That is generally the policy matters. Now, in this view of the matter, my lord, where is the occasion when they initially came up with startup? Now, why they did it? Because, my lord, in the previous meeting, 2 startups, including the petitioner, were there. They are eradicating, my lord. And this is not the first tender. Kindly see the tenders earlier they issued, my lord. If you also kindly come to page 23. On 1/8/24, my lord, page 23.
Yes.
Kindly see, my lord. If you lordship will kindly come to page 23, my lord.
Yes,
Somewhere in the bottom, startup exemption for the years of experience, yes. Let the lordship notice that. Then my lord will kindly, this was on 1/8/24. Then my lord will kindly come to page number 45. My lord, page 45. We, my lord, by mistake, we have given this 21/8/23. It should be 24/8/21. It should be 21/8/24, my lord. By mistake, either we have filed an additional affidavit or brought on. Here also kindly see, my lord, startup exemption for turnover, yes, last page. Startup exemption, yes. Now, my lord will kindly come to paragraph 7 for a moment. Para 7. That after cancellation of the earlier tender, another tender being so dated 21/8/24, the one I'm referring, or 25 session was issued by so. In the same tender dated 21/8/24, similar exemptions were granted to startup at clause 2, like earlier tender dated 1/8/24. The virtual pre-bid meeting pursuant to the same tender dated 21/8/24 was held on 27/8/24, and the representative of the petitioner raised a query on the exemption available with regard to bidder turnover criteria and experience criteria for startup bidder. It is stated that during the pre-bid meeting, the other prospective bidders had also raised certain objections regarding the conflicting nature of the conditions between GM clause and buyer-aided bid specific clause with regard to past performance and experience criteria required from the bidder. However, respondents, without giving any reply to the objections and queries raised by the prospective bidder, including the petitioner, had cancelled the tender dated 21/8/20. Now, my lord, whenever they notice that there are persons who are with startup, now therefore wipe them out. So that, my lord, they can give the work to their blue-eyed boys. Now, please come to the interim tender record. At page 69. Page 69. The 7/9/24. Startup exemption for the year of experience and turnover, no. No. There are two things, my lord. Number one, they cannot. They cannot say will not give this, extend this benefit to startup. Assuming, for the sake of argument, my lord, it is within their province. They'll have to show some good reasons why in the earlier two tender there was, now it is not there. And that reason must be, my lord, acceptable to your lordship. Then only question of giving due deference to their decision would arise. Therefore, my humble submission is, my lord, they are just eradicating the tenderers who could be prospective competition. They want to confine the competition to a handful so that, my lord, they can use their discretion. Therefore, my humble submission is, my lord, this prescription in the tender that they will not give the benefit of the Government of India notification is arbitrary and it cannot withstand to research. And what happened, my lord, as far as the queries which we made in the pre-bid meeting, they have come up with a reply. Now, all the reply are stereotypes. There is no application of. So, my lord, whether state can say will not follow central prescription. And it's not that, my lord, the policy of the Government of India to give benefit to the startup is confined to the central sector. This committee is. And the jail portal itself is sponsored by the central government. Right? So the idea is to, my lord, ensure transparency in the entire process. Therefore, my lord, this prescription in the tender, in my humble submission, cannot withstand the reason.
That's all.
Now, the lordship's kind permission.
Ajay.
Absolutely.
I want to show that there was absolute transparency. There is nothing arbitrary, my lord. I would like to take your lordship to that bounce of document. These are part of our record, my lord. As instruction I have received, page 28, my lord. Page 28 of that, my lord.
Page 20.
Page 28. First tender was floated, my lord, on 1/8/2024. Under what circumstances that was to be cancelled is recorded in this page 28, my lord.
Yes.
This is dated 28/2024. Regarding the tender for procurement of text paper for printing of free textbook for the forthcoming academic year 2025. An emergent meeting under compelling circumstances after it was brought to the notice of the management of the ASTPP, Assam State Textbook Production Publication Limited, by several intending bidders that a bid document for procurement of 70 GSM surface size Maplitho text paper white bid number so-and-so dated 1/8/2024, that's the first tender, my lord, had technical flaws as the APSTTP Limited had marked the bid in favor of MSME, which therefore does not permit other bidders to participate in the bid. It has fully restricted the participation. The MD ASTPPC Limited explained that this issue had cropped up as the GM interface was changed and custom bid was not permissible. The ASTPP Limited did not have the expertise in the new format and had no knowledge of what will be the outcome if MSC is clicked as allowed in the prescribed field box in the GM portal. Hence, MD ASTPP Limited requested the committee members that either the restrictive bid should be continued or this bid has to be cancelled for wider participation. As this a detailed discussion was held, the draft bid is placed before the SLEC for decision. A detailed discussion was held and the committee examined the matter and observed that since the MSC had to be unmarked, and it is expected that big manufacturing mills are intending to participate, hence the criteria of minimum 10% of experience should also be enhanced to 20% so that there is competition among the manufacturing mills. Also, it was observed that that last year the lowest split ratio was 10%. So during the last year, the provision of 10% was fixed as minimum performance criteria. This year, the minimum split ratio, it is not relevant to this. Basically, when we put that preference to MSC, medium scale enterprises, none other can participate in the GM portal. That was the difficulty. So we withdrew, we canceled that tender. Then we went for a second tender. In the second tender, what we faced, finds at page 17, because of which the impugned tender has been issued.
Just a minute. Page
Page 17 of that one,
17.
117. This is 3/9/2024. This is the decision that preceded the impugned tender, third tender.
Yes.
An emergent meeting under the compelling circumstances where the MD informed that the bid floated for the second time is again reflecting contradictory characters between the GEM generic clauses and the Assam Textbook Corporation in respect of past experience. And the paper category still remains ambiguous. It was discussed with the GEM. GEM also came to us, my lord, Deputy Director, where a draft bid was experimented. The draft bid in respect of MSC startup turnover, if marked yes, then separate point gets automatically generated, which allows exemption from participation for performance criteria also. The committee felt that the supply of text paper is a critical component with high risk factor in terms of large volume from delivery, maintaining the quality and short notice supply under any circumstances. Hence, past performance is an important factor to assess the ability of the participating mills. Therefore, the committee has suggested to unmark this point also in the GEM portal. The category within the Maplitho paper had the option to bring further clarity. All this exercise to bring clarity required the removal of the sum of the GEM generic conditions, which were contradictory in nature. Accordingly, the draft bid is placed as sample before the SLEC for consideration and decision. The draft bid was placed in the SLEC for consideration. Having mandated the critical task of providing 3.5 crore number of textbooks, it's a huge number, my lord, to 58 lakh students in the state of Assam, it is considered that the task and procurement of executing the task within a strict time schedule, maintaining the chain of events smoothly, is in the public interest and safety. Any failure on the part of the ASTTP to provide free textbook may lead to serious consequential events in the state. Hence, the laid down priority of past performance is crucial and critical in the entire exercise of this huge procurement that shall be taking place. So, my lord, these are the criteria we inserted again. Clause F, supply history. They submitted certain representations, my lord. Those representations, for that also we had convened another meeting.
This is with regard to the experience.
Yes, they are agreed there. My lord, we are not
What
saying
about turnover?
both are relevant, my lord. Both are relevant. We are not saying they cannot participate. If they have
So the problem was caused in the GEM portal.
yes, if we
So now
allow,
you're not going to do it through GEM portal.
we are going to do it,
We're
through
going to do it
Zen portal,
through-
but the exemptions we are not granting, because if we allow only MSME or startups, my lord, the Zen portal automatically grants exemption, my lord. Or
To everyone.
exactly performance and financial soundness. There are so many criteria that gets diluted, my lord, which we cannot take that risk, my lord, considering the volume of the work. 3.5 crores books to be published and to be distributed to 58 lakh students throughout the state, my lord. So that's why, my lord, our decision is absolutely based on regions, my lord. We never intended to grant relaxation. It is the GEM portal which automatically generates those relaxation criteria, my lord. That's why now we have changed it. We are not barring anybody from participation, but they have to have past performance criteria, my lord, because we cannot take risks with, my lord, new publishers. It is their own stand on affidavit, my lord, on oath at paragraph 2, that recently they have procured a machine, my lord. So apparently they have no experience, my lord. So that criteria, my lord, we never intended to give. It was because of automatic creation by the GEM portal, it was done. If my lord peruses page 78 for a moment, my lord, of the writ petition. This is the circular they are harping
Yes,
on, my lord.
yes.
Page 78, it is addressed, in fact, to all central ministries, departments, PSUs,
No,
all
I
concerns.
noticed. None of them are addressed to the state.
No, it is absolutely our jurisdiction, my lord. And even, my lord, the last one that they are relying, that says regarding exemption from this criteria. Clause 3, page 80, my lord.
Yes.
However, there may be circumstances like procurement of items related to public safety, health, critical security, operations and equipment, etc. Why etc.? Because it is not exhaustive, my lord. Even if we assume, my lord, these are applicable for state corporation. This is a state government company, my lord, textbook corporation. Even if it is applicable, this etc. allows us to not to follow this condition because it is not exhaustive, my lord.
So this page 80
My lord.
also allows the central government
To insist for past performance, to insist for, my lord, other experience
depending
criteria.
upon.
Yes, my lord.
So it's not a blanket
My
direction.
lord, kindly consider on the 3.5 crores books. If a, my lord, new player, somehow he fails, my lord, entire education system will be affected, my lord. 58 lakh students will be waiting for books, my lord. So that is why past performance is very relevant. All along, my lord, we are insisting on it. This time also, our record indicates we are insisting for past performance. Automatically, the Zen portal grants exemption, my lord, for which we cannot be blamed. And law regarding, my lord, tender condition is absolutely subtle, my lord. Unless it is fraught with malice, it is extremely arbitrary, my lord. We cannot be faulted with. Silpi construction is directly on that point, my lord. And this record doesn't indicate, my lord, that we wanted to favor someone. This record indicates, my lord, our only endeavor is to smooth printing of books and delivery of books, which is in larger public interest. Petitioner private right perhaps may have been violated, my lord. But that may not be a case, my lord, to interfere in this writ petition, my lord. If my lord, that's Silpi construction justice. My lord knows that. Silpi construction. Input modification. I don't. There are so many judgments right from Tata Cellular, Silpi Construction, then Michigan Rubber Mill. Terms of tender are otherwise not automatically amenable to reach jurisdiction, my lord.
Which para?
Effectively, my lord, para would be paragraph, my lord, I would rely on paragraph 7 that speaks about Tata Cellular. Paragraph 7. In Tata Cellular versus Union India, it has been held that judicial review of government contracts was permissible in order to prevent arbitrary and the principle enunciated in this case are serial number 4, terms of tender not amenable to reach jurisdiction, and my lord, FCON infrastructure case. Then paragraph 20 is the ratio of these. My lord knows that it has been relied upon time and again, my lord. The essence of law laid down in the judgment referred to above is the exercise of restraint and caution, the need for overwhelming public interest to justify judicial intervention in matters of contract involving state.
Anything else? That's all.
For reply, my lord, can be under sometime.
No. We cannot have it in parts and parcels. We are having a hearing. Cannot come in the middle.
In that bunch of document, my lord.
There's nothing else. There's no reply. What reply is there?
The
Yes, submission. is
document
there.
that has been before lot.
Huh?
My lord.
I've got it. I've got it. Here.
The document are translated by my senior, my lord.
What document?
That bunch of
My
yes.
lord. It is just, my lord, furnished to us, my lord.
Yes, it has been furnished to me now also. There's nothing.
But my lord, during the
This is the reasons.
during the pre-bid meeting, my lord, they can very well bring it before the readers, my lord.
What?
During the pre-bid meeting, when we.
No, you see, Mr. Counsel. The earlier, the pre-bid meeting with regard to the earlier NITs, that is a closed chapter now. For the simple reason that you have not made a challenge to the effect that those earlier NITs should be acted upon. It is not your case. Your only case is that in this present NIT, the latest NIT, the clause regarding turnover and experience clause. That has to be put in there. That's your only case.
My lord, as the JAM is the, my lord, central government portal, my lord. They have to follow
So they have not made JM a party, my lord.
the Ministry of Finance, Union of India is a party, my lord.
JM is the tendering authority. They have not made JM also a party, my lord. But page 2 and 3 of that bunch are my written instruction to me, my lord. Followed by those, supported by those part of the record, my lord. That I have.
Right. Right, Mr. K. Chowdhury, learned senior counsel for the petitioner, as well as Mr. R.M. Dekha. No, assisted by Mr. R.M. Dekha. Also heard Mr. P.N. Goswami, learned addition lady, Assam. For all the respondents,
1, 2, and 3, my lord.
for the respondents number 1, 2, and 3. Assisted by Mr. I. Kalita. Who appears for the respondents number 4 and 5?
That's the central
Ministry,
comment, my lord.
CGC,
CVC will be there.
Mr. S.S. Roy. Appear for the respondents number 4 and 5. Right. The petitioner is aggrieved with the tender notice bracket, no comma here and after referred to as the NI, tender notice dated 7/9/24, comma here and after referred to as the NIT dated 7/9/2024. Wherein the exemptions that were earlier provided to startups in respect of the bidder turnover and experience criteria. Bidder turnover, you may invert commas, huh? And experience turnover also invert commas. Have been omitted. Pusta. The petitioner's case is that the NIT dated 7/9/2024 should be set aside. Wherein tenders, wherein tenderers have been invited for supply of 9700 MT of surface size map litho paper with mill watermark for the academic session 2025 of the schools. So thereafter, the respondent should issue a fresh tender, issue a fresh tender, issue a fresh tender,
21/8/2024.
huh?
On 21/8/2024.
What?
After 1 and 21, it was issued, madam.
We should issue a fresh tender by making provisions for exemption of bidder turnover criteria and experience criteria in terms of the policy circular dated 10/3/2016, comma, OM dated 25/7/16 and OM dated 20/09/16 issued by the the first one is this policy circular issued by the Ministry of Micro, comma, Small and Medium Enterprises, comma, Government of India, and OM dated so and so and so and so, huh? Issued by the Ministry of Finance, Department of Expenditure, comma, Procurement Policy Division. Yes, sir. The petitioner's case is that the respondent number, the respondent number 3 had procured 70 GSM map litho paper with mill watermark. This is the academic session of 2021. So, however, from the academic session of 2022, comma, the respondent number 3 started inviting tenders for supply of 70 GSM surface size map litho paper with mill watermark. And from the academic session of 2023, comma, the respondent number 3 started inviting tenders for supply of the same 70 GSM surface size map litho paper mark with mill watermark through the government e-marketplace, comma, herein after referred to as GEM, GEM, huh? This is para 4 of the writ petition. Okay. Next para. The petitioner's counsel submits that GEM is a national public procurement portal and an end-to-end online marketplace from where the central and state government ministries slash departments, comma, CPSUs and SPSUs affect the procurement of goods and services. So, he also submits that prior to the impugned NIT dated 7/9/2024. The respondent number 3 had issued two other NITs dated 1/8/2024 and 21/8/2024. Wherein exemptions had been granted to startups in respect of the bidder turnover criteria and the experience criteria. So, however, the earlier two NITs were cancelled and the new NIT dated 7/9/2024 was issued without providing for exemptions to startups as stated in the foregoing paragraphs. Next paragraph, the petitioner's counsel submits that a pre-bid meeting dated 27. No, the pre-bid meeting was held on 27/8/2024. Pursuant to the second NIT dated 21/8/2024. Wherein the representatives of the petitioner had raised a query on the exemptions available with regard to bidder turnover criteria and experience criteria for a startup bidder. It was stated during the pre-bid meeting that the other no. What's that? In the pre-bid meeting, other prospective bidders had also raised certain objections regarding the conflicting nature of the conditions between the GEM clause and the buyer added bid specific clause with regard to the past performance and experience criteria required from bidders. However, the respondents, without giving any reply to the objections and queries raised by the prospective bidders, including the petitioner, had cancelled the tender dated 21/8/2024. Next paragraph. The petitioner's counsel submits that when there are clear clarifications and directions issued by the Ministry of Micro, Small and Medium Enterprises and by the Ministry of Finance with regard to the exemptions to be given to startups regarding the bidder turnover criteria and experience criteria, while making procurement from startups, while asking for bids from startups, the state government cannot have the competence to say that it would not follow the clarifications and directions passed by the central government. The learned senior counsel submits that the prescription provided in the impugned NIT dated 7/9/2024, which also requires startups to submit their bidder turnover criteria and experience criteria, is arbitrary, and as such, the same would have to be set aside as it cannot withstand judicial scrutiny. I think that's your case. Next paragraph. Mr. P. N. Goswami, the learned additional legi, on the other hand, submits that in terms of the earlier NIT, whenever the when conditions were provided, now wherein conditions were provided for grant of exemptions to startups, the GEM portal automatically granted exemption / relaxation to all other tenderers / bidders, even if they were not startups. Then, right. He submits that the earlier tender, NIT is dated 1/8/24 and 21/8/24 were cancelled. Why were cancelled? Page were cancelled. Where is that? As the bid floated, as the bids floated or tender, NIT, NIT, as the NIT again reflected contradictory characters between the GEM generic clauses and ATC in respect of the past experience and the paper category still remain ambiguous. That's all.
Basically start up as DSB. Then separate point that gets automatically directed.
Further, if the MSc / startup turnover was marked yes, then separate points stood automatically generated, which allowed exemption from performance criteria also.
We cannot.
He also submits that as the critical task of providing 3 crores numbers of free textbooks to 58 lakh students was mandated in the state of Assam, it was considered that the task and procurement and execution of the task within a strict time schedule, maintaining the chain of events smoothly, was in public interest and safety. Or else serious consequential events could follow. Hence, the laid down priority on past performance was crucial and critical to the entire exercise of this huge procurement. The learned additional AG submits that in view of the above decision taken by the state level empowered committee, SLEC in short, right, Rose? On free textbooks held on 3/9/2024. Was the reason that the impugn NIT dated 7/9/2024 was issued. Next, you're right. The learned additional AG also submits that the central government circulars dated 1/8/2020, no, dated 10/3/16, 25/7/16 and 29/16 are not binding upon the state government and its instrumentalities, inasmuch as the said circulars and OMs have been made applicable only to central ministries slash departments slash central public sector undertakings, etc. He submits that as the he submits that as the tendering authority is the author of the NIT, knowing its own requirements. This court should not, this court, a judicial review of the decision of the state government to impose the conditions of bidder turnover and bidder turnover criteria and experience criteria upon the startups should not be interfered with. I have heard the learned counsels for the parties. It'll take some time. I'll finish it. Order is out. Twelve. Para 12. Para 12, huh? Para 12. Okay. What to do? You come on the second last date. What to do? Suddenly you all wake up in the last minute. But then this also very short time was given. What to do? Your last minute, and what about us then? We are caught in the middle. Huh? Item 5. Let's put this in the document. Item 5. Where is the petitioner? What type of a writ petition is this? Not to disturb. It is not even a provincial high school. All no, nothing in writing. No, last time, as agreed to by the learned counsel for the parties. Release this matter after 3 weeks, on a date to be fixed by the registrar. Right. No one appears on behalf of the petitioner. Full stop. Miss Yudas appears for? Eleven also. Okay, right. This writ petition has been filed. Now, for a direction to be issued to the respondents number 11 and 12, comma, not to disturb the functioning and the activities of the district special residential school for handicapped children, comma, Darang. Next paragraph. The petitioner's case is that though it has applied for provincialization of the school, comma, the school has not been provincialized till date. The grievance of the petitioner is that the respondents number 11 and 12, that is the officer in charge, Dula Police Station, District Darang, and Dula Regional Physically Handicapped Development Association, represented by the President cum Secretary, Village Hirapara, had suddenly appeared in the petitioner's school on 26/8/16 and 27/8/16 and had threatened the petitioners and the children therein to shift the school. Gustav. The respondent number 11 and 12 came again on 3/9/2016 and threatened the petitioner and his children. Gustav. Next paragraph. The affidavit in opposition filed by the respondent number 12 is to the effect that the writ petitioner number 2 was removed from the post of headmaster on the basis of resolution number 3 passed by the general meeting held on 27/8/16, convened by the secretary of the petitioner's school. Gustav. Further, the writ petitioner number 2. Now further, on the basis of an FIR filed by the respondent number 12 on 26/4/2016 before the OC Dula Police Station, Dula PS case number 190/16 under section 353/294/409/506 IPC was registered. And the writ petitioner number 2 was also arrested. Next one. On perusing the averments made in the writ petition, comma, there is no document to show that the petitioners were ever threatened by the respondents number 11 and 12. Yes, sir. All the allegation made by the petitioner is all appears to be all verbal. Yes, sir. Yes, sir. However, as no one appears for the petitioner, this court is of the view that the petitioner is not inclined to pursue the writ petition. The writ petition is dismissed as infructuous, dismissed for non-prosecution. And only one thing you write, before that, before that sentence you write, in any event, comma, that's all, enough. Got that. Item? Huh? Eight. What has taken place? You tell me what has taken place. No. This is a 2017 matter, Mr. Counselor. Cancellation was done in 2017. Affidavit in opposition has been filed in 2017. After 7 years, if you're not filing anything, then nothing remains. For what? For what? To say what? What development has taken place? Who told you development has taken place? Then you tell him to come. You tell him to come now. Yes. Yes. This is a 2017 matter, Mr. Counsel. Then? No, I know. You come to page 10, para 10 of your affidavit. We'll call your officers. This is not the way. The 2017 matter. On the last date, March 24, instructions are awaited. What is this? I think we'll call your officer, let him come personally here. I don't think so. You are not interested in pursuing this matter seriously. 2017 matter. So you'll come with after the week and you'll state that you still have not received. Right. Mr. S.H. Raman appears for the petitioner, while Mr. B. Chaudhary appears for the APDCL. The para 10 of the affidavit in opposition filed by the respondents number 228 on 18/1/2019 states that out of the total 14 petitioners, final determination of payable and receivable amounts of the 12 petitioners has been completed. Full stop. However, in respect of two petitioners who are at serial number 6 and 11 of the chart provided in para 10, comma, the process of final determination is under consideration of the chief executive officer of the respondent number. Let me see. Of the chief executive officer, comma, Guwahati's electrical circle dash Roman 2, comma, APDCL bracket LAR. Right, close. So your parent 10 is the one. Full stop. Next para. Mr. B. Chaudhary shall place the up-to-date status report with regard to para 10 of the affidavit in opposition filed by the respondents number 228. List the matter on Monday, 23.
11.
Madam. Huh? But why didn't you file any affidavit? 5.5 years have passed, madam. You have also got a duty towards court. There's no work order. Right, no one appears for the petitioner on call. As per the, it is seen that no one had appeared for the petitioner on 12/1, on the last date, comma, that is on 12/1/2024. Ms. M. Kalita, the learned counsel for the respondent numbers 1, 3, 4, and 5 submits that though the petitioner has claimed non-payment of contractual dues, comma, the petitioner has not annexed any work order to the writ petition, even though 5 years have passed. So, stop. Next para. As no one appears for the petitioner, comma, it appears that the petitioner is not interested in pursuing the matter. The writ petition is dismissed for non-prosecution.
12.
Right. No one appears for the petitioner on call. It is seen that the petitioner had not appeared on the last date also. The present case, no, Mr. Mbuya appears on behalf of Mr. B. Gogoi, learned counsel for the PW. Pusta. Next para. This is a petition for release of the contractual bill of rupees 89,000 for the works done in the year 2001-2005. Pusta. As no one appears for the petitioner, it appears that the petitioner is not interested in pursuing the matter. The writ petition, of the writ petition is accordingly dismissed for non-prosecution. All these cases. What to do? Right, no one appears for the petition on call. While Mr. S.S. Roy appears for the state respondents. In the interest of justice, list this matter after 2 weeks. Huh? After 2 weeks. Yes. You're claiming 28 lakhs and they are emitting 15 lakhs. Then what remains? Can we go into the other facts in a writ court? No, they have not denied. They've admitted 15 lakhs. Sorry. You go in. When did you complete your contract work? Huh? 2018. 2018. You go civil suit. Money suit. Huh? Haha. So yeah, that's all. Yeah, I think you have admitted 15 lakhs, correct? No, where is it? I think it's there in your affidavit. Page 481. 481, it is here. So you pay the amount, 15 lakhs, and for the remaining, you go to the civil court. This is by the district commissioner. Then, huh? Please read. Does it say deputy commissioner? Yes, still in the. Yes, now the government here has said that they should now be called district commissioner. Same like Bombay, we used to call Bombay, now is Mumbai, what to do? So new name. Okay, right. Right, Mr. Learned Counsel, S.P. Bhattacharya, Charji, Learned Counsel for the petitioner, and Miss Yudas, Learned Counsel for all respondents. The petitioner's grievance is that though the petitioner had supplied various materials to the office of the district commissioner, Dimaji, from the year 2010 to 2018, against various work orders, the petitioner has not been paid his entire contractual dues. So he submits that the respondents are liable to pay to the petitioner the balance unpaid bills amounting to rupees 28,16,587. Correct? On the other hand, Mrs. Udas, learned counsel for all the respondents, submits that in terms of the affidavit filed by the District Commissioner Dimaji, Assam, the petitioner is still to be paid an amount of rupees 15 lakhs. In terms of letter number TND -50 /1 / 15/2023 -T and D DMJ dated 26/7/20 no dated 30/8/2023. Huh? Signature is 30/08/2023. Huh? Issued to the director (DCP) Transformation and Development Department, Dispur, Guwahati. 6. This is at page 481. Huh? Next. In view of the fact that the state respondents have admitted that they are liable to pay rupees 15 lakhs to the petitioner out of the petitioner's claim of unpaid bills amounting to rupees 28 so, this court directs the respondents to pay the 15 lakhs to the petitioner within 4 months. Huh? A 2019 matter, Mr. Counsel, it's okay. Within a period of 4 months from today. Huh? Okay. Okay. We have a period of 4 months from the date of receipt of a certified copy of this order. Full stop. Next para. With regard to the unadmitted amount, the petitioner has the liberty to approach the civil court, if so advised. The writ petition is accordingly disposed of.
50.
I think since you've completed the work in 2018, there shouldn't be any problem with limitation. Section 14 will be there. Item? Huh? Where is the demand proposal? Let's see. What is this? Utilization certificate of amount released till date not available. What do you mean not available? 9.5 lakhs. So this is being sent to whom? When will it be sent to the government? Huh? Correct, Mr. Upadhyay, learned counsel for the respondents. Respondents except the finance department, submits that the proposal for payment of the contractual dues of the petitioner has been prepared by the office of the chief engineer, irrigation, and the same will be sent to the irrigation secretariat within 2 days. He submits that irrigation department secretariat shall thereafter send the proposal for sanction of the amount to the finance department. List the matter after 3 weeks. Huh? Give a date. Why? You're not well. Okay. He's not. Pleadings are complete. Pleadings are complete, I think. No, reply has to, huh? Everything is ready. Everything is ready. Okay, right. Mr. I alarm Learned Counsel for the petitioner pays for adjournment on the ground that he is not feeling well. It is noticed that pleadings are complete and as per the prayer of the petitioner's counsel, list the matter on after a week. List the matter after a week. There's stay order in your favor.
17.
Yes, madam, what to do? Miss D. Jane, Learned Counsel for the Water Resource Depot, is granted 3 weeks time to obtain instruction and file a petition. Huh? Give a date.
Ultimately,
Yes, madam. You file affidavit? Oh, I have not got it. When did you file? 13/9. Oh, that means on Friday. That way not. Yes, yes. So what, admitted? Health department. Who is? No, but where is the health department? Which para? What is the amount? Okay, let them come. Let their health department come.
19.
Okay, health, okay, we'll take that up. Sir, Triple S, please wait. Just a minute, wait. Yes, madam, they have admitted the amount. So, the vehicle was hired by whom? By the district administration. Okay, district administration of which district? Government. Okay, right. Heard Mr. D.K. Mishra for the petitioner. Also heard Ms. S. Sharma for the health department, as well as Ms. U. Das for deputy commissioner. So sub Ms. M. Barwa, R.M. Barwa appeals for respond number 5. So sub right. The petitioner's counsel submits that the petitioner firm had been providing vehicles to the Kamrup Metropolitan District Administration. No, Kamrup Metropolitan District Administration for the use of the health department for vaccination purposes during the COVID pandemic. Next para. The grievance of the petitioner firm is that the petitioner has not been paid hiring charges of his vehicles amounting to rupees 11,17,243. Miss Udas, the learned counsel for the for 4. Who is for 4? Who is for 4? Yes. So there is learned counsel for the respondents number 4 and 6 submits that the authorities have not yet released the outstanding payment that is due to the petitioner firms, though the bills have been duly received and verified by the authority. However, the fund requirement for payment of the said hiring charges is to be made by the Director of Health Services bracket FW and the how does that is the respondents number 2 and 3. She submits that the fund requirement for payment of the dues of the petitioner was submitted by the District Immunization Officer, Kamrup Metro District, Assam, to the Director of Health Services bracket FW, wide letter number additional full stop CM and HO bracket KM slash ESSTT full stop slash 118 dated 22/3/2023. Full stop. Ms. Yuda submits that the payment for the hiring charges would have to be paid by the respondents number 2 and 3 to the petitioner. Full stop. It'll be through the district administration, no? Through the district administration. Next para. Mrs. S. Sharma, learned counsel for the respondents number 2 and 3 submits that as the bills of the petitioners have been verified and pay, 1, 2 and 3, 1, 2 and 3, okay, Mr. Shama, 1, 2, 3. Has been verified and found that the petitioner is liable to be paid rupees so and so, the respondents number 1, 2, the respondents are directed to, respondents number 1, 2 and 3 are directed to place the required amount before the respondent number, before the respondent number 4 and 6. And pay the same. And pay the said amount to the petitioner. The entire exercise should be concluded within a period of within a period of 3 months from the date of receipt of a certified copy disorder. Read petitions accordingly disposed of. You tell them make it on the report.
Item 19.
Okay, right. Mr. Mbuya, appearing on behalf of Mr. B. Goel, learned counsel for the PWD submits that parawise comments have been received. He submits that he will be filing affidavit within 2 weeks. List the matter after 2 weeks. You were there.
Item 20.
Or 20 and item. Okay, right. Mr. M. Buyan is granted 3 weeks time to obtain instructions and file affidavit in this matter. This is the matter on, no, it's not tagged. This is the matter on 23.
Item 21.
Will be filed when? Okay. Oh. Right. Okay, right. Miss, whatever. Mrs. Udas, learned counsel for the respondent submits that affidavit is being filed today. Full stop. She submits that there is a dispute with regard to the amount claimed by the petitioner, in as much as the petitioner had submitted one bill twice. This is the matter on when? Monday.
22.
For what? It's only a question of whether you, huh? $54 lakh, 54.94. No, 54.94 has to be paid, correct? Right. And the petitioner's case is that the balance security deposit amount of rupees 54,94,071 has not been given to the petitioner, despite the petitioner having completed the contract work and having been given all his bills. Ms. D. Jain shall obtain instructions as to why the balance security deposit has not been released to the petitioner. When? This is a matter of Monday.
23 to 25.
Huh? Where, page? See? Ah. Which page is the liability, huh? 42. Yes, is this water resource department? Huh? From the? No, where have you submitted your bills? To whom? To whom? Yes, what to do, madam? Have you submitted his bills to the district administration? Yes. Correct, correct. No, but for payment, they have got to forward it. Right, Mrs. D. Jane shall obtain instructions as to whether the liability certificate, packet page 41-42, right close, is admitted by the Water Resource Department. And as to whether the bill of the petitioner has been forwarded by the Water Resource Department to the district administration. Mr. N. Mr. S.R. Barwa, Learned Counsel for the District Commissioner shall also obtain instructions with regard to the above. This is the matter after 3 weeks. Give it it. 4950, and in the third one? Forty. By this week, Mr. B. Gogoi, Learned Standing Council Health Department submits that para-wise comments have been received and he will be filing his affidavit by 2009. List the matter on 25.
49.
Admitted amount. So it's an admitted amount. Maybe. Huh? Maybe, but you are the one who's supervising the work. You are the one who has to verify whether the bills are paid or not. Correct? Who is to pay the amount? Mr. Counsel, there's a simple question. Who has to pay the amount? Who? Yes, who is to pay the amount according to you? Huh? Who is to pay the amount? You are appearing for 7, 8, and 9. No, you are appearing for respondent number 4, 4 to 6. Who is appearing for the sports and youth department? Yes, why not releasing the amount? How much is your claim? How much is your claim? That is the remaining balance amount payable. El- 11,33,000 is still payable. How much is admitted by you? Huh? What? How much? Maybe that's not the question this court is asking. Yes. Correct. You're not mentioning 2019 matter. Mister? J. Abbas appears for the petitioner and submit that as on date, the liability of the respondents with regard to non-payment of the petitioner's contractual dues amounts to rupees 11,33,000. Mr. S.R. Barwa appearing for the respondent's number 1, 2, and 3 and 7. And Mr. T.R. Gogoi for respondents number 4 to 6 shall obtain instructions with regard to the exact amount of contractual dues still payable to the petitioner, if any. List the matter when. Give a date before holidays. Make it 26.
350.
Come to para 4. Of the affidavit opposition. You go to civil court. Maybe then assurance, then you don't need the court. No need. 2019 matter, Mr. Counsel, this will not do. This is you had more than 2 years to file any affidavit that you wanted. You have not filed. Come to para 5 of their affidavit. Please read. Please read slowly and loudly. Then you go to civil court when this is the stand. This is a writ court. We cannot go into disputed questions of fact. Huh? You file a civil suit. You go to a court. You go to a civil court. Because of this, where is the question? Heard, Mr. B.K. Das, Learned Counsel for the petitioner. And you should not make submission while eating a tamul. This is not the way. Next time you eat your sandwich, you eat your tiffin also. Heard Mr. B.K. Das, learned counsel for the petitioner. Who submit, no, also heard Mr. C. Sharma appearing for the other respondent. Mr. The petitioner, this case is that the petitioner has not been paid his contractual dues for executing various work, for executing contract work under the scheme, namely, it is here, in the synopsis. Various contract works, you say, okay? The petitioner's case is that the petitioner has not been paid his contractual dues amounting to rupees 4,77,768. Despite the petitioner having submitted his bid and representations dated 27/12/2017. Oh, sir. Next para. The respondent's case, on the other hand, is that there is no evidence to show that the petitioner had duly executed the works in question and fulfilled the relevant condition necessary for submission of demand of fund. As such, no demand of for fund could ever be submitted without fulfilling the conditions under the established norms and procedures. Accordingly, the petitioner was not entitled to the amount claimed in the writ petition. I have heard the counsel for the parties and also perused the amendments made in the pleadings. The opposing stand taken by the parties show that opposing stance taken by the parties in the amendments made in the writ petition and affidavit filed by the respondent number 2 show that there are disputed questions of fact which would require the recording of evidence to enable the court to decide the issue regarding payment of alleged contractual dues of the petition. As this court is ill-equipped to deal with issues regarding disputed questions of fact, this court is of the view that the petitioner should approach the civil court with regard to his claim for non-payment of contractual debt. Accordingly, the writ petition stands closed with liberty being given to the petitioner to approach the civil court with his grievance, with his grievance, if so advised. 51. Yes, what is your case? Huh? What is the problem here? On the basis of NIT dated? Zero one zero nine 23. Did you submit your tender for this? But the earlier tender has become infructuous. Huh? Which one? What is the same case? No. No, what is this? This order is different. This order is with regard to non-payment of call deposit. Forfeiture of call deposit. Huh? Huh? These are different. No. The submission of the bid by the petitioner pursuant to the NIT dated so shall not prejudice the petitioner in the instant proceeding. Order of the court, it shall not prejudice him. No. So you have participated in the latest 30/12/2023. And in the earlier bid, the earlier tender notice was dated 1/9/23. Is it? And in that 1/9/23, you were the third highest bidder. And one and two have been, they have you are the highest bidder in the earlier NIT. Correct, but when number one and two have gone, then only you remain. Huh? That tender was not forwarded to you by the DC. They have cancelled it. Has it been cancelled? Just let me see. Page 26. Yes. Where are you reading? Page 26. Which paragraph? So he challenges. He has challenges. What is wrong? Just a minute. One at a time. He has challenges. He has challenged the cancellation. So no, I mean, no, with regard to whether he has a right or not, that is not the question. He has got a right to cancel, no doubt. But whether his cancellation was correct in the circumstances of that case is an issue to be decided. But this court has allowed it. Just a minute, Mr. Counsel, let me read also. We'll take it up some other day. On the brother part, list the matter after a week. Next.
27 for order.
Item. This is too much. 2000. I am not disposing. I am not disposing. This is a contempt. If you are not, I am going to have, huh? Right, we send to budget. Then council for? Huh? For number 1 and 2, submit that. Please for 2 weeks time to obtain the latest status report with regard to the contractual dues payable to the petitioner amounting to rupees 6, how much? 7,04584 lakhs. This is the matter on, give a date this month. No, before that. Okay. Okay. 1st October.
28.
Huh? What do you mean by third party check? Well, there cannot be ignorance of law. So what is wrong? So what is wrong? So so I'm ready. You carry on. I'm ready. No. You have not ready the 2017 matter, Mr. Counsel. Sorry if you are not ready. You go ahead. Go ahead. You see, when you have admitted to wrongdoing in a writ petition, in an oath, on oath, what remains? Huh? You have admitted. You have admitted. Look at para 13 of your writ petition. Please. Actually, once you're caught, you have to repay. Come to your para 9. Yes, yes, there is admission very much. Carry on, carry on. You see, these now, you see, these are these are within the competence of the authority. Then, when you have admitted, here's the question. Where's the question? You were caught doing a legal act. You're justifying it because of your wife being sick and she eventually dying. You have not paid back the entire amount. 50,000 still remains. What only? Even if it's only 20,000, it's important. 50,000. Actually, once you get caught, you will want to repay. In fact, you'll be ready to pay even more, double the amount also, maybe triple the amount also. But you have not paid the amount back also. Naturally, naturally. You have admitted it. Okay, we tell them to have an inquiry. Let them have an inquiry. Nothing, will continue. Ah. Okay. Correct. Once he is admitted, where's the question of inquiry? Ah. You see, you please look at all the appointments given for government servants, central government servants. Nowhere will it say that. No, forget the third party check. The very fact that you have not repaid the entire amount. You have admitted in your writ petition. What is that club? No, I don't know anything about that. I've got no idea about it. Only thing is that I just know from the government that you are not honest. No, you have admitted that you have not repaid 50,000 till now. Naturally, but then that is not the way it should be done. Two wrongs don't make a right. So even if it's one wrong is a wrong. This is a question of fact. Everybody. That will depend entirely on them. This. I don't know. They can pay. Yeah, because you see, this court, this is a writ court. The only thing we have to see here is whether their action is arbitrary, unreasonable, illegal. With regard to, you see, we cannot say that, why don't you, is not a case that it is a case that you have not repaid in full. Naturally, once you are caught, naturally, you pay from some other source the 50,000. No, not at this stage. Not after so much water has gone under the bridge. Not at this stage. This writ petition is itself of 2017. When was it terminated? His agency? 2015. Once you start repaying, shows that you have admitted your guilt. What remains? Then why should they have a person working for them who is defrauding them? But was third party check allowed as per rules? Regulation. Huh? 8. We'll take it up at 2. We'll dispose it of it. Huh?
Oblige.
There. Huh? Clause 4 of what? Clause 4. Huh? Regulation 4. Appointment of agent. What's this? Regulation 8. Okay. Okay. Sure. Yes. Page? Yes. Mhm. Where is the letters? Where is the no show cause notice? Show cause notice dated? Huh? He's funding his own business. Hmm. They are not submitted. Then they correct. The admitted case. I am assuring you that such type of incident will not happen in future. You bring the order. Where is the citation? You give it to me. Okay, right. Heard Mr. A. Bhattacharya, learned counsel for the petitioner. Also heard Mr. S. Nath, learned counsel for the respondent number 1 to 4. The petitioner has paid for setting aside the impugned order dated 30/3/2016. comma, by which the order dated 30/03/2015 passed by the Senior Divisional Manager, LIC, LICI, terminating the agency of the petitioner was upheld. The petitioner has thus prayed for setting aside. No, that's all. The petitioner has also thus prayed for terminating, no, for setting aside the order dated 30/03/2015. The petitioner's case is that the petitioner was an agent of the Life Insurance Corporation of India Limited, bracket LICI short. And due to his sincerity, comma, honesty and hard work, he became the member of ZM's Club LICI, Bokakat branch. While he was working as an agent for the LICI, the petitioner was issued the divisional manager, LICI, issued a letter to the Jorhat Divisional Office. No, issued a letter to the respondent number 4. That a vigilance case had been initiated due to non-realization of a huge amount of money by issuing third-party checks in the Bokagat branch office during 2005-2006 onwards. On investigation of the report submitted by the investigating officer. No, you say the letter also stated that on investigation of the report submitted by the investigating officer, the involvement of the petitioner having agency code number 00310/44F was established regarding financial irregularities by depositing third-party checks. Accordingly, payment of commission was to be stopped to the petitioner along and to another agent, that is Mr. Chandan Dwara agency. Mr. Chandan Dwara, let's say Chandan Dwara. Full stop. Subsequent to the above, a show cause notice dated 7/2/2015 was issued to the petitioner, wherein the irregularities committed by the petitioner were spelled out and the petitioner was informed that he was to give a reply to the show cause notice within a month, as the petitioner's acts were prejudicial to the interests of the LICI and its policy holders. Full stop. Not full stop, comma, which was in breach of Rule 8 bracket 4 read with Rule 16 bracket 1 bracket small a and bracket small b of the LIC of India bracket agents bracket close rules 1972. The petitioner was also informed that the LICI proposed to impose upon the petitioner the penalty of termination of agency with recovery of rupees 1,03,255, which was the outstanding amount as on 5/12/2014. Anyway, this is what has been written here in the show cause notice. Full stop. Next paragraph. The petitioner's counsel submits that though it is admitted by the petitioner that he had committed a mistake, comma, the petitioner should have been given a lesser penalty than termination of the agency. Full stop. Is that correct? Wherever my thing is wrong, please correct me. He further submits that even though the petitioner had admitted his mistake, comma, the petitioner's agency could not have been terminated without any inquiry having been initiated against the petitioner. Full stop. He further submits that next paragraph, the petitioner's counsel submits that it was the earlier practice in the LICI to whatever I said, let's consider that it was a practice prevalent at the LICI for depositing third-party checks at the counter number 13 of the LICI Bokakat branch. Full stop. Accordingly, the petitioner deposited the checks at counter number 13 of the LICI Bokakat branch, and the same were accepted without any complaints. Full stop. However, some of the checks issued by the petitioner were returned unpaid, due to which the petitioner on his own has repaid a considerable amount of money to compensate for the same. Full stop. He also submits that no loss has been caused to the corporation or to the interests of its policy holders by the actions of the petitioner. And as such, the petitioner's agency could not have been terminated when the petitioner's acts were not prejudicial to the interests of the LICI or to the interests of its policyholder. Next paragraph. The petitioner's counsel further submits that the petitioner has repaid all the amounts payable to the LICI and only an amount of rupees 50,000 is still payable by the petitioner, which can be recovered by the LICI from the commission the petitioner is to receive from the LIC. He further submits that due to the illness of the petitioner's wife, a mistake had occurred, which would not occur again. He further submits that the petitioner's wife, has expired in the meantime. That's all. Also, Mr. S. Nath, learned counsel for the LICI, on the other hand, submits that no inquiry was initiated against the petitioner, in as much as the petitioner had admitted to his wrongdoing pursuant to the show cause notice issued to him. He submits that as the petitioner has admitted to the wrongdoing as enumerated in the show cause notice dated 7/2/2015. No. Enumerated in no, that's not. To the show cause notice dated 7/2/2015, which has been, what have I said? No, admitted to his wrongdoing in his reply dated 6/3/2015 to the show cause notice dated 7/2/2015. There was the initiation of our inquiries would serve no useful purpose. Yes. No. Haha. Okay. Okay, what do I say? Which was not which was the termination of the petitioner's agency by the impugned order dated 30/03/2015 by the respondent number three was done in terms of clause 16 clause 16 bracket 12 bracket No, clause 16. Regulation 16, no? Regulation 16 bracket A. 16, it says 12 bracket. What is this 12? Where does this 12 come from? Come to 34. Oh, it is 1 actually. 16 bracket 1 bracket A. Comma bracket B of the LIC of India bracket agents regulations, comma 1972. Hereinafter referred to as the 1972 regulation. Further, a recovery of rupees 55,162 was outstanding against the petitioner as on 12/3/2015, which was payable by the petitioner. No, senior division manager. Senior division. Senior division is 3. Senior division is 3. Further, no, Pusta. He accordingly submits that as there is no infirmity with the impugned order of termination of the agency of the petitioner, the writ petition should be dismissed. Correct. Anything else? That's all, no? I have heard the learned causes for the parties. As can be seen, no, learned causes for the parties. The show cause notice dated 7/2/2015 and the petitioner's reply dated 6/3/2015 is reproduced herein below as follows. Page 26, 27 and 30. Okay, next paragraph. As can be seen from the reply dated 6/3/2015, the petitioner has admitted to the fact that he has used the money collected from policy holders for investing in his LICI business. Oh, sir. He has also wrongly put his name with regard to an amount of rupees 26004 instead of the policyholder, Mr. D.K. Saike. Further, rupees 50,000 is still lying outstanding with the petitioner, which the petitioner has admitted, which the petitioner has undertaken to repay within a short time. The petitioner has also admitted that he has committed a mistake and that such types of incidents would not happen in the future again. First off. What else? Next para. The petitioner in para 9 of the writ petition has admitted that he has repaid all the amounts payable to the LICI and that only an amount of rupees 50,000 was to be recovered from him, which could be recovered from the commission payable to him by the LICI. He has also stated that he did not have any malified intention in defrauding the money of either that of the policy holders or the LICI, but the circumstances and the situation at that time was such that he was in need of huge amount of money for the treatment of his wife, although his wife expired on 20/05/13 at GNRC hospital. Next, the admission by the petitioner with regard to the use of policyholders' money for his own private purposes is implied in the petitioner's averments made in the writ petition and in his reply to the show cause notice. As there is an admission made by the petitioner with regard to the with regard to his actions which are not in the interest of the corporation. No, which are not expected of an LIC agent. And the same not being in the interest of the corporation or the policy holders, comma. This court is unable to find is unable to find, no, this court is of the view that there is no infirmities in the impugned order passed by the respondents. Full stop. When the petitioner has, in his reply to the show cause notice and in the affidavit, in the writ petition, admitted to his mistake, comma. It cannot, there is no requirement of having a further inquiry in terms of clause 16 and 17, clause 16 of the clause regulation 16 of the Life Insurance Corporation of India bracket agents agents close regulations common 1972. Full stop. Which is reproduced below here as follows, 16, take it down, okay? I'm considering, no, in view of the above reasons, this court does not find any ground to interfere with the impugned order. The writ petitions accordingly, impugned orders, the writ petitions accordingly dismissed.
29.
What you do is you withdraw with liberty to file afresh, better. By legal there's no point. You are not going to get you have not been able to communicate for so many years. 2019 matter. Right, Mr. M.J. Vara, learned counsel for the petitioner, submits that the petitioner has expired in the meantime. Yet has expired. And though he had prayed for time on 24/2/2023 to take appropriate steps, comma, he has not been able to communicate with the legal heirs of the petition. Yes, he accordingly submits that he may be allowed to withdraw the writ petition, with liberty to file afresh if the cause of action still arises with the legal heirs of the deceased writ petitioner. Miss F. Ahmed appears for 5 and 6 and Miss Udas appears for 1 and 2. The prayer of the petitioner's counsel is allowed. The writ petition is dismissed with liberty as paid for.
30.
Yes. Yes, I know. Yeah. Individuals, correct. No, you see, what is that? You see, actually it will be for individual. It cannot be for, unless they are living in a dormitory-like situation, dormitory-like room. So you see, it says here that unless, are they, the only thing you have got to see whether they are illegal encroachers on the land. Where, you see, if you say that they have got to pay for the transformers, where is your letter to them? Yes? What is required? No, wait, just a minute, madam. Where is the letter issued to them that this is the requirement? Why don't you go before the division bench? This is the order of the division bench. No, it is the order of the division bench. Come to page 29, page 28. Come to page 20, it's a PIL order. Come to page 30. Page 29, come to 29. Go to the bottom. Go to the bottom. Chief Justice. Yes. Yes. No, maybe, madam. Acha, okay. Or link it. Yes. Earlier they were having electricity or not? No, the simple thing is whether they are encroachers or not. What? For necessary payment for what? Transformer is costly. How many persons are there? No, what they are saying is that the transformer has been dismantled. They are not saying that it is working or not. It is not there. No, Mr. Council, this is of this order passed by the division bench is of 2022. 2 years have passed. So they have been without electricity for 2 years. Where is the application? Where is the application in your petition? Is it a part of your petition, madam? Why do I have to spoon feed you? This is my question to you, that's all. There's some contradiction in the order. It says, in case the members of the petitioner committee are found to be illegal encroachers, they cannot claim any benefit on the ground of their electricity connection being restored by the order of the court. Just a minute. You have got to restore electricity connection whether they encroachers or not. Then where is your particulars? It says that the members of the petitioner committee will accordingly furnish detailed particulars to the authority concerned about electricity being provided to them earlier, before the eviction drive was conducted. Where have you said that the individual details are furnished? In your subsequent to the order of the division bench. Madam, please come to page Come to page 31. Please read the second paragraph. Where have you said here, not in words? Where have you said? After filing contempt. No, madam. Please file an affidavit showing me where you have given your particulars. Show me that you have applied because the division bench has said the members of the petitioner committee will accordingly furnish detailed particulars to the authority concerned about electricity being provided to them earlier before the eviction drive was conducted. So where is the particulars that? Miss Madam, that they will do. You have to do your part first. Where is your part? You're not furnishing. Right. Miss Kisom, learn counsel for the petitioner shall produce the particulars as provided in the order dated 8/6/22 passed in WPC. In WPC 4842 of 2021. Which is to the following effect. Page 31. Bracket you write, invert commas you write, the members of the petitioner committee will accordingly furnish detailed particulars to the concerned authority. Now, to the authority concerned about electricity being provided to them earlier before the eviction drive was conducted. Full stop. Invert commas close. Page 31. Second paragraph. Next, Mr. KP Pathak. Counsel for respondent number. Counsel for all the respondents submits that. No, it is directed to inform this court as to whether the petitioner had applied for electricity connection for all its members. And whether any communication with regard to temporary electricity connection has been provided to the petitioner by the APDCS. List the matter next week. Give. Next week on Wednesday. Or next week Friday. Full stop. The Mr. KP Pathak shall also obtain instructions as to whether the APDCL has issued any letter to the petitioner with regard to a new transformer being required to be set up and the cost of the same. Full stop. He shall also obtain instructions as to why the earlier transformer from which the petitioner had been getting their electricity cannot be used for giving temporary electricity connection to the petitioners. For giving temporary electricity connection to the petitioner. This is the matter next week. Wednesday, Friday. You get people? Take this order. Next Friday. Item. That is one aspect. Now all these writs, I think they are all infructuous. We'll allow you and we'll also dismiss all this. There is only an attempt to delay the matter. Item? What is your name? Mr. DJ Mehdi, learned counsel for the petitioner, submits that the writ petition has become infructuous. Ms. Udas appears for all the respondents. The writ petition is accordingly dismissed as infructuous. Item 35. Then for in item 36. In item 36, you are for respondent number 4. But who is there for the petitioner? Thirty-two, 34, and 36. Infructuous? Yes. Miss F. Begum, Miss F. Begum, counsel for the petitioner, submits that the writ petition has become infructuous. Mrs. Udas appears for the state for in all. No, there's 32, 34, 36. 1 to 5. In 32, Miss Udas appears for just 1 to 5. 1 to 5. Huh? In 31, just a minute. 31 is not there. Just a minute. Then what about in 34? Wait, 33? No, 34. 34. 1 to 3, huh? In 1 to 3, the item 34, Miss Udas. And in 36? One, two, three again, huh? Then in item 36, Mr. DJ Mehdi appears for point number 4. Okay. Then just write the prayer of the petitions council, the submission made by the petitions council, and the writ petition is dismissed as infructuous. Item 32, 34, 36. Okay, that's gone. Now who is for 35? Huh? DJ Mehdi, we have finished. Huh? Okay, then 33. Huh? Okay, now we'll take it away. Now let us come to page para 31. Item 31. We allowing and we're dismissing the writ petition. Also. No notice to the petitioner. Not required. That is what you wanted, I think. Is it? And what is this section 3 and 4 of the CPC? Where is it applicable? Order 3, but you have said section 3. Huh? Okay. Okay, heard Mr. F. Count, learned counsel for the applicant / writ petitioner who submits that the applicant / writ petitioner has taken the brief back on 30/09/2020. And as such, he seeks leave to withdraw his Vakaratnama under Order 3, Rule 4 CPC. Just show me under Order 3, Rule 4 CPC. Next para. No, he also submits that in this regard, the applicant slash writ petitioner has submitted a certificate dated 30/09/2020, wherein it has stated that it is going to engage some other lawyer to conduct the above case. So, in view of the above, yes, who is following 31? Who is the counsel for government? Huh? Mr. J. Handik appears for point number 2. While Ms. U does appear for 1, 3, and 4. The prayer of the applicant's counsel is allowed. The application is according, the applicant, no, the counsel for the applicant is accordingly allowed to withdraw his wakalatnama. The application is accordingly allowed and disposed of. And next, in the next, give me the main case. In view of the order dated today, passed in IA number so and so, the writ petitioner's counsel has been allowed to withdraw his wakalatnama, as the brief had been taken back by the writ petitioner from his counsel in the year 2020. Full stop. Next para. No one appears for the petitioner. The present case pertains to settlement of the Dibru Part 1 fishery, Tinsukia district, temporarily, wide order dated 2/11/2020. 2010. 2/11/2000. During, there was no regular settlement, correct? Never. During the temporary settlement of the said fishery had been extended. Correct, but that time no. That's what. The temporary settlement of the fishery had been extended from time to time. However, it has been stated, when was that regular settlement made? Any idea? 23. Anyway, this is that. The petitioner's prayer in the writ petition is to allow the petitioner to run the said fishery temporarily on the strength of the order dated 2/11/2010 till finalization of a tender process. Where is that order of the this court where temporary has not been allowed? On considering the fact that the petitioner has prayed for temporary settlement of the fishery which he has been operating from 2/11/2010 without any tender process, this court is of the prima facie view that the prayer of the petitioner cannot be allowed. In any event, it appears, it has been, who appears out here? Mr. J. Handik, at the beginning, right? Mr. J. Handik appears for this point number 2, while Mr. U. Das appears for 1, 3, and 4. It has been stated at the bar that the said fishery has been put to tender in the year 2023 and fresh settlement has been made. Next para. And at the bottom, you right? As the petitioner has not engaged any other counsel despite taking the brief back from Mr. S. Count, learned counsel for the writ petitioner in the year 2020, this court is of the view that the petitioner is not interested in pursuing the matter, the writ petition is accordingly dismissed as not for non-prosecution. So he can always apply for restoration. Yes, item. No one appears for the petition on call. In the interest of justice, list this matter on next week. Mrs. Das, you are here in item 33. Mrs. Udas appears for 1 to 4, huh?
Item 47.
I have to issue notice first, Mr. Counselor. Without notice, there is no question of taking steps. Why should steps be taken? Why should steps be taken? When? Show me where. I don't have that notice here in my thing, in my copy. Where have you got in your copy? Yes, you see this. Give him the court copy. Tell me where notice has been issued. And then you can start arguing the matter. Okay, what is the case about? What is wrong with the order? Yes. 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 So what is wrong? Why, what is wrong? Where is Mr. SCKL? Where is he? Let us see this judgment, Ashish Agarwal's judgment. Yes. Please read. Correct. Now, even this case, it was issued prior to the, as per the unamended 148. Here also it was unamended 148 notices were issued. So what is wrong? And I want to show you something. Please come to para 4. Please read para 4. Page 14. Earlier you did not have any quarrel, now you're having a problem. And what is the difference between this the writ petition that was disposed of and the Supreme Court judgment? The notices are all the same. Notices were as per the unamended 148, which were deemed to be thereafter considered to be under 148A. What is wrong? Huh? So, correct. So it is the same as the Supreme Court judgment. What is wrong? Unfortunately, you're not the counsel for the income tax. That's the problem. Otherwise, I'd have dismissed your case right now. You tell Mr. Kayal to appear. He has not come twice. He's not coming to discuss. The first time it was listed, he has not come. The second time also he has sent you. Tell him to come. When? Not tomorrow. Thursday. Huh? Which one? Oh, those. This will not take long. Wednesday's list they have made already, no? Okay, list this matter. On the prayer made on behalf of Mr. SCKL, list this matter on Wednesday. You tell Mr. SCKL that the notice is issued were under the unamended 148, similar as that judgment. So what is wrong? And he has not objected, now he's objecting. What is this? Same order, 38.
Item 29.
Yes, what to do? Where are the councils? What to do? Huh? How much? How much is the balance? Is still to be paid. Oh, only 4 lakhs. After this contempt petition. I think after the contempt. Miss RM Deka accepts notice on behalf of point number 6. That's what been said. Where is she? Is she around? Who is for the water resource department? Huh? RM Deka is. What to do? Can you tell him to come? You don't know them. Okay. Right. Petitioners council is present, however, no one appears for the respondents. This is the matter. Give a date. Next week. Oh.
24. Item 40 to 42.
Huh? Item 40. Okay. Number 2 died. So wife. Okay, Mr. R.D. Learned counsel for the applicant. Prays for substitution of the writ petitioner number 2, who died on 12/8/2017 by his wife, namely Mrs. Sarita Devi, age 42 years, wife of late Dharam Rai, Kalita Kuchi railway line, Purban Nagar, PO Udayan Vihar, District Kamrup M, PIN 781171. Mr. KK Parashar, counsel for All the respondents submits that he has got no objection to the same. What? Death certificate not annexed. And 2017, now you are asking for the substitution. When was it filed? What is this matter about? Regularization, how is it here before this bench? How can it be before this bench? This is a bench-free matter. So I cannot take it up. No. Just right, heard Mr. Ardell, just say, Mr. KK Parasal. No, leave it, huh? Leave everything. Leave everything. Just say Mr. KK Parasal, learned counsel for the state respondent, for the respondent submits that the matter pertains to bench 3. Full stop. In view of the above, comma, registry to verify the same and list it before the appropriate bench. Forty-three. This Singsan petrol pump have been damaged by a landslide. It's flattened by the retaining wall. Huh? So you had made an application for reconstitution, which was to include the wife of your brother. Huh? Oh. That was not? So full of intrigue. Anyway, right now the petrol pump is not functioning. I don't think it will function for some time. It's fully flattened. Correct. It's on the side of the road. You can always see it every time I go towards the airport and back. Anyway, so what do you want? Time for Mr. S. Bhattakur, Learned Counsel for the respondents number 2 and 3 is granted 4 weeks time to file affidavit in opposition. Mr. S. Roy, you're there? Miss N. Kalita on behalf of Mr. Miss K. Fukan, counsel for the respondent number 1. You want to file affidavit? No. Submits that she will not be filing any affidavit. Correct? Correct? Okay, right. Office note, next para. Office note dated 6/9/2024 indicates that notice was issued upon the respondent number 4 on 3/9/2014. However, there is no service report on respondent number 4 till date. This is the matter. No, await service report, and you also write on the prayer of the petitioner's counsel, Miss S. Chakravarti is also allowed to serve notice upon the respondent number 4 by registered by dusty service and file affidavit thereafter. This is the matter after 4 weeks. Indicated. So these writ petitions can be allowed. Huh? Okay. Mr. B. Sharma, learned counsel for the petitioners, submits that affidavit in opposition has been served upon him when? On 13. On 13/9. To which he needs a week's time to file a reply. He needs 3 days time to file a reply. Prayers allowed. Leaves the matter on Monday. Full stop. No, Tuesday we're fixed items, I think, Next Tuesday, nothing fixed. Okay, this is the matter on next Tuesday, huh? The registry shall place the affidavit in a position filed by the state respondents in the record. The prayer for the consideration on the prayer for interim order will be considered on the next day. Same order in all of them.
Supplementary orders, item 52.
Supplementary order 50. To retender? Okay, you're for whom? You're for the municipal board. So you retender the amount, have a retender. Because none of them have the experience. Who is for the private respondents? Your I is for what? So all now you see. Correct.
Already has the power. Decide whether that body is or not. However, before saying that now it's given taken in their IA also. Therefore, no feature at this point. Therefore, the purpose of the application for work and before the RBA, they have issued a general.
Correct, but then you did not have the essential conditions.
The not extensive
But they have taken a stand that no one had the. So they are the best author. They are the best interpreter and person. might have been difficult after they have taken a stand that no one had the experience.
No, their stand is, as they were bidder, which had the extensive.
No, but you see, in that case, the petitioner also would, then he would have applied, he would have, but then because of that condition, he did not apply. Maybe, maybe. Unfortunately, they have taken a stand, yes. So that, otherwise, maybe. Show me. Yeah, for the board. You file you issue a fresh tender. That's what, no? To all bidders and potential bidders. Unfortunately for you, they've taken a stand. So what remains? No, yes, stand whatever, we understand. From your affidavit, it is clear that you have accepted that no one has that experience. And accordingly, it has to give it to you. Anyway, so, right, heard Mr. A.M. Barbuya, learned counsel for the applicant. Applicant Municipal Board Hailakandi. Also heard Mr. B. Goswami, B. Kaushik, learned counsel for the applicant in WPC. Applicant in 2696, IA 2696 of 2024. Better we'll do the entire case better. Don't say that. This heard Mr. H.I. Chaudhary, learned counsel for, heard you, H.I. Chaudhary, learned counsel for the petitioner. Also heard Mr. A.M. Barbuya, learned counsel for the Municipal Board Hailakandi, and Mr. B. Kaushik for the respondent number 6. And Ms. U. Das appears for respondents number 1, 2, and 4. Give me the writ petition. The petition, next para. The writ petitioner's grievance is that a tender notice, is that a notice inviting tender, bracket NIT, dated 12/2/2024, was issued by the Hailakandi Municipal Board from approved and eligible class 1 contractors / firms having extensive experience of similar nature of works for number one, establishment and commissioning of material recovery facility bracket MRF bracket close and waste compost plant bracket W2C bracket close against processing and disposal of SWM of Hailakandi town. And number two, development of sanitary landfill bracket SLF bracket close at Kuchila, Hailakandi and the SWM project at Hailakandi town. Full stop. This is the synopsis you'll get. Full stop. Next para. The petitioner who was otherwise eligible for participating in the NIT did not participate in the same as the petitioner did not have extensive experience of executing similar nature of works as stated above. Next para. The petitioner, however, came to learn on 15/3/2024 that only 2 bidders had participated in the NIT dated 12/2/2024, and though both were evaluated as technically qualified bidders, both of them did not possess the requisite criteria of having extensive experience in similar nature of works. First, the petitioner's counsel submits that even though the bidders who had participated in the NIT did not have the essential condition of having extensive experience of executing similar nature of works, the Hailakandi Municipal Board proceeded to award the contract to the respondent number 6, as his bid was the lowest. Next para. The petitioner's counsel submits that as the 2 bidders who participated in the NIT, did not have the essential condition required, the entire selection process has become V-shaped. As such, the NIT dated 12/2/2024 and the subsequent selection of the respondent number 6 in pursuant to the said NIT should be set aside. Next para. This court, in its order dated 8/4/2024, had passed an interim order directing that no work order should be issued in pursuant to the NIT dated NIT dated 12/2/24. Next para. The Municipal Board Hailakandi has filed IA Civil 2770/2024, praying that the interim order passed by this court on 8/4/2024 should be vacated / altered or alternatively to grant leave to the Municipal Board Hailakandi to retender the contract with modified and suitable terms and conditions. Pusta. Next para. The respondent number 6 has also filed IAC 2696 of 2024 against the interim order dated 8/4/2024. Praying for alteration / modification / vacation of the interim order dated 8/4/2024. Pusta. Mr. A.M. Barbuya, Learned Counsel for the Municipal Board Hailakandi, submits that the two bidders who participated in the NIT did not have the essential condition required of a bidder, that is, having extensive experience in similar nature of works. So, he submits that in view of the above, he however submits that as the work was of an urgent nature, the work was awarded to the respondent number 6. He submits that this court should either vacate / alter / modify the interim order dated 8/4/2024, or in the alternative, allow the the Municipal Board Hailakandi to issue a fresh tender, NIT, to issue a fresh NIT instead of the NIT dated 12/2/2024 with suitable modifications. Next paragraph. Mr. B. Kaushik, the Learned Counsel for the respondent number 6, submits that in view of the stand taken by the Municipal Board Hailakandi and keeping in view the law laid down by the Supreme Court in the case of Central Coalfields Limited and other versus SLL-SML (joint venture consortium) and others, 2016 8 SCC 622, the Municipal Board Hailakandi has the option to call for a new tender. Correct? And the board, Hailakandi are empowered to deviate from the terms and conditions of the tender. That's all. Next para. I have heard the learned causes for the parties. It is an admitted fact that none of the bidders had the essential condition of having extensive experience in so as required in the NIT dated 12/2/2024. In the case of Central Coalfields Limited and other, Supra, the Supreme Court has held that The issuance of acceptance or rejection of a bid or a bidder should be looked at not only from the point of view of the unsuccessful party, but also from the point of view of the employer. Full stop. The terms of an NIT cannot be ignored as being redundant or superfluous, and they must be given a meaning and the necessary significance. Full stop. Whether a term of the NIT is essential or not is a decision taken by the employer which should be respected. Full stop. Even if the term is essential, the employer has the inherent authority to deviate from it, provided the deviation is made applicable to all bidders and potential bidders, as held in Ramana Dayaram Shetty. Full stop. Full stop. Next paragraph. On perusing the averments made in the affidavit of the municipal board Hailakandi, it is clear that the bidders, including the respondent number 6, did not have the extensive experience in similar nature of works as provided in para 4 of the said affidavit. So, despite the above, the municipal board had awarded the contract to the respondent number 6. So, however, in terms of the judgment of Central Coalfields Supra, the employer has the inherent authority to deviate from an essential condition, provided that the deviation is made applicable to all bidders and potential bidders. Full stop. Anything else? Full stop. Potential bidders. Full stop. However, in this case, though the petitioner was a potential bidder, due to the fact that the petitioner did not have the essential condition of extensive sensor, the petitioner could not participate in the tender process. Full stop. The finding made by the municipal board the deviation made by the municipal board would, if the same had been made known earlier to all potential bidders, would have allowed the petitioner to participate in the tender process. On considering the above facts and in view of the judgment of the Supreme Court in Central Coalfield Limited and other versus Supra, this court is of the view that the alternative prayer made by the municipal board Hailakandi should be allowed. Comma, that is, they should be allowed to submit, they should be allowed to float a new NIT in respect of the above contract work. And we are, with suitable and suitable modified conditions. Full stop. Consequently, the the Hailakandi Municipal Board is accordingly allowed to issue the new NIT, and consequently the earlier NIT dated transfer should be cancelled by the Hailakandi, by the Municipal Board Hailakandi. The writ petition and the two IAs are accordingly disposed of. Common order, huh? Yes. What happened here? Did the petitioner appear? Huh? This PDS license was suspended and cancelled in 17. Affidavit was filed in 2017. Now what remains? So we've got to see the legality of the order. Yes, what to do? No one appears. Right, no one appears for the petition on call. Ms. Udas appears for the all the respondents. The matter pertains to the suspension and cancellation of the petitioner's PDS license on 31/1/2017. Affidavit in opposition was filed by the respondent number 6 on 18/4/2017. So, what is action? Okay, then what is your name? NJ? Mr. What? NZ, NZ, NJ, NZ, Z. Chaudhary appears on behalf of Mr. A.R. Buyan, learned counsel for the petitioner. Since appears for such, that is it. Then right? Mr. N.J. Chaudhary submits that, appeals that he may be given a week's time to obtain instructions from his client with regard to whether the writ petition has become infructuous. List this matter when? Give a date. Please. So this bench 4 was being held by whom earlier? Okay.